I'm Hugh Spitzer, and I'm one of the 4 faculty members teaching one of the sections in Transnational Law. Welcome everybody to our section for half of the time today. We'll start all together for 40 minutes total, and then go back to our own sessions, and people in the other sessions obviously can then sign out and log on to theirs. We have a special guest today, Allyn Taylor, and she is an affiliate professor here at UW Law. She's taught at Georgetown, at the School of Public Health, and Johns Hopkins in International Relations. And she has worked as a legal advisor to WHO, World Health Organization, and continues to do consulting work with them. And she is going to talk to us about the international health regulations and in connection with COVID-19. Allyn, take it away.
Thank you. I want to thank the faculty for giving me an opportunity to join you this afternoon. It's a pleasure to be here in a very difficult time, though. You know, the outbreak of COVID-19 that was first detected in Wuhan in December has taken the world by surprise. In the short time since the start of this pandemic, it has shown how woefully unprepared the global community is for our shared vulnerability to emerging and re-emerging pathogens. The human toll of COVID-19 is crushing. Midweek this week, the total confirmed cases exceeded 3.6 million, and the total number of global deaths from this disease has exceeded 250,000. And the speed at which it has traversed the globe is simply astonishing. According to the U.S. Centers for Disease Control, the CDC, the disease had spread to virtually every country on the planet by mid-April. By comparison, the SARS epidemic of the early 2000s, a virus that was widely hailed as evidencing the globalization of public health, had only spread to around 25 countries in about the same period. Countries have responded to this outbreak by implementing various types of unilateral national public health containment measures. Researchers at the University of Oxford have compiled data on a range of government response measures, such as workplace and school closures, to create the stringency index and track national responses over time. But as you can see, the national responses vary considerably in their degree of stringency, and there's no synchronicity amongst countries in implementing national containment measures. And as we're going to discuss further today, this lack of strong, consistent, and coordinated public health response really bodes poorly for our capacity to control this deadly pandemic. It's a truism of modern epidemiology that diseases do not know national borders. Unless this virus is contained everywhere, it can't be contained anywhere. And I think for the purposes of our law class, this also reflects the global vacuum in leadership. Indeed, global solidarity, coordinated action, and leadership has been notably absent in the global fight against coronavirus. As the New York Times noted, there doesn't seem to be a global plan to address the disease. But there actually is a legal framework, a binding legal framework. The International Health Regulations, or the IHR, adopted by member states of the World Health Organization, or WHO. WHO is the specialized agency of the UN system in health. The basic idea behind the WHO regulations is that WHO would serve as a central coordinating body in global public health emergencies, and countries would undertake surveillance, notify WHO of outbreaks, and share information to help scientists control disease. And WHO, in turn, would coordinate containment efforts, declare emergencies, and make recommendations to guide national actions. But as we're going to discuss in detail over the next half hour, WHO has not taken up the mantle of leadership, and states are not implementing their IHR commitments. And all of this undermines our efforts to protect public health. So understanding the IHR and the role of WHO and why international cooperation is failing in this pandemic is the subject of today's lecture. Following a brief review of the history of infectious diseases, we're going to delve into the IHR and the actions of state parties and WHO to draw some early lessons for infectious disease control and global health governance. To begin with, disease has been the unwelcoming traveling companion of international trade and commerce throughout history. With the development of national and international commerce, epidemics of disastrous proportions swept nations and decimated populations. For example, Italy's monopoly of trade during the Middle Ages was highly conducive to the dissemination of epidemic diseases throughout Europe. Venice, one of the world's leading commercial powers at the time, suffered 63 major epidemics of plague between the years 900 and 1500. Of particular importance in the history of diseases is Black Death, one of the deadliest pandemics in human history. The plague is thought to have evolved in China and then spread throughout the Middle East and Europe. The global total number of deaths caused by plagues is outstanding. It's been estimated that Black Death reduced the global population between 25 million and 75 million persons. And of course, international trade and conquest brought epidemics of epic proportions to other parts of the world. For example, when the Spaniard Cortés pushed across Mexico and Central and South America in the 16th century, his armies also unintentionally brought along smallpox. And smallpox is estimated to have killed 3 million people in Mexico in the year 1520 alone. And then, of course, in the last century, the 1918 flu, also known as Spanish influenza, took an estimated 20 to 100 million lives worldwide. The fight against infectious diseases and the control of their transfer of across international borders is one of the earliest fields of international cooperation, and in fact, one of the first domains in which an international organization was created. The first efforts towards infectious disease diplomacy took place in Europe in the 19th century. During this period, waves of communicable diseases were sweeping across Europe, accompanying the growth of railways and steam navigation. In response to pandemics, individual countries would traditionally try to control the spread of disease by unilaterally applying strict national quarantine measures and national border controls. However, these measures were often ineffective in controlling epidemics, and they were also serious obstacles to international trade because such measures tended to differ from country to country and often from port to port, even within the same country. So the inadequacy of these unilateral national measures and their negative impact on international trade prompted infectious disease diplomacy and public health cooperation. The first International Sanitary Conference was held in 1851, and notably, public health cooperation from the very beginning was as concerned with facilitating international trade as it was with the protection of public health. The maximum protection of public health with minimal restrictions on trade became the guiding principle for the first International Sanitary Conference and all conferences and agreements that followed until the present day. WHO, upon its founding in 1948, inherited from its predecessor organizations the responsibility to address the international spread of disease, including the management of the international legal regime for infectious disease control. Regulations were first adopted by the Fourth World Health Assembly in 1951, and these regulations have been subject to a number of revisions resulting from global improvement in knowledge and control of epidemic disease, and were most recently revised in the year 2005. Now, in the years between 2005 and the last previous revision in 1969, there have been a number of developments that had highlighted the inadequacy of traditional approaches to global infectious disease control. Of particular note was the globalization of infectious diseases. In the last 3 decades, nations worldwide have been confronted with dozens of emerging infections, and these have included newly recognized pathogens such as HIV, Ebola, and Zika. In addition, in the same period, we've witnessed the virulent reemergence of old infections such as tuberculosis and the rise of antimicrobial resistance, which has also threatened the lives of hundreds of millions of people worldwide. Now, of course, as we've discussed, infectious diseases have raged through human communities throughout history. However, the forces of globalization, including rapid growth in international trade and travel, have amplified their speed and impact. Dramatic changes in social, political, and environmental factors has also contributed to this new era in which new infections are expanding and many old diseases once thought and controlled are now increasing. Spectacular population growth and poverty has led to overcrowding of cities, forcing millions of people to live in unsanitary conditions that are ripe for infectious diseases. At the same time, political and economic instability and war has also resulted in the massive movement of peoples and microbes and increased the likelihood of spreading new infectious diseases to populations with no previous experience with the pathogens. And changes in land use and ecological degradation, including global warming, is affecting the introduction and spread of many diseases. Now, as a consequence of these factors and others, we're living in an era which is unprecedented evolution in and greater pressure for disease emergence and transmission globally. Indeed, between 2011 and 2018, WHO tracked almost 1,500 epidemic events. And indeed, COVID-19 is the quintessential example of the globalization of infectious diseases, evidencing that the worst case scenario predictions of epidemiologists can come true in a modern and interdependent world, and evidencing the need for effective international cooperation. So the globalization of infectious diseases that began to rile up in the 80s highlighted many of the pre-existing problems with the old international health regs and initiated global interest in revising the regulations to make them a more effective instrument for international cooperation. One of the key issues is that in the early 90s, it was clear that many of the concepts related to borders and frontiers that were contained in the old regs needed to be re-examined in light of modern epidemiological principles. In particular, as I'm sure you all know, we live in an era now where the sheer volume of contemporary international travel and its rapid speed, in which the duration of a journey is often shorter than the incubation period of a disease, thwarts efforts to try to control diseases at borders. Effective control over the international spread of disease requires sound epidemiological services at the source and rapid exchange of information. So galvanized by the SARS epidemic in the early 2000s, member states of the WHO completed the negotiations of the new international health regulations, and they were formally adopted in May 2005 and entered into force in 2007. Now, the regulations were adopted pursuant to Article 21 of the WHO Constitution, which is truly a unique contracting out device that is designed to simplify and encourage binding international agreement. Pursuant to the WHO Constitution, the regulations come into force automatically for all member states, except for those who notify the executive head of WHO, the Director General, of any rejection or reservation within a specified period. So unlike treaties, there is no requirement for separate state ratification. Today, the regulations are binding international law for 194 states worldwide, and indeed, it's one of the most widely subscribed to agreements in the UN system. The fundamental purpose of the new regulations rests upon the same principle that has guided the sanitary conventions since the mid-19th century: maximum protection of public health with minimal interference with world traffic. And although the fundamental purpose remains largely the same, the new regs were designed to achieve this objective through a fundamental paradigm shift based upon these modern epidemiological principles, that instead of focusing on borders, the IHR is designed to improve global capacity to prevent, detect, and respond to infectious disease threats. Now, the new IHR receives this paradigm shift from the old regs in three key ways. So first, I want to tell you, the IHR, which is not assigned today, is like over 100 pages. It's very, very detailed. So in short shift, the three key ways in which it tried to achieve the paradigm shift is first, vastly expanding the scope of diseases subject of the IHR. Secondly, dramatically expanding state obligations, and third, significantly expanding WHO's obligation to provide global coordination. And I'm going to discuss each of these in turn in light of the challenges of implementing the IHR in the context of COVID-19. So first of all, the new IHR greatly expands the scope of disease outbreaks that are subject to the international regulatory regime. The new IHR applies to any broadly defined event. An event is defined by the new IHR as a manifestation of disease or an occurrence that creates the potential for disease. And then the term disease is also broadly defined as an illness or medical condition, irrespective of origin or source, that presents or could present significant harms to humans. So as a consequence of these broad definitions, a wide range of events are now subject to the IHR. The events can be biological, infectious, chemical or radionuclear, known or unknown, or emerging or re-emerging. So the new international health regulations meet expanded obligations and responsibilities for state parties. States are under a legal obligation to cooperate in good faith with WHO in implementing a number of tasks. And while I don't have time to address all of these today, I want to identify and discuss three key commitments that are being routinely ignored by states during the present pandemic. So first and most significantly, many states have not implemented what's known as core capacities that are required by the IHR that are essential to detect, notify, and respond to infectious disease outbreaks. Under the new IHR, state parties are mandated to achieve and maintain a set of core capacities in their respective national health systems at the local, intermediate, and national level. The central premise of the IHR is that rapidly detecting and stopping diseases at their source will support improved disease prevention and control within and between countries. Now, building and maintaining these surveillance requirements as required by the IHR requires substantial technical and financial resources. And state parties have the primary obligation under the new IHR to provide the resources to meet their own surveillance requirements. And this has been a huge problem. And failure to implement the core capacities has been a huge problem. And I think one of the key challenges with the new IHR is that they did not include a financial mechanism for high-income states to assist low-income countries in building this capacity. And the consequence is that many states have not done so. And the overall consequences for us as a global community are dire. There have been a number of reports on this, and most recently, a report issued by a WHO expert committee just in September showed that after 15 years, the gap in surveillance capacity is grim and remains unresolved. According to this report, 2 months before COVID-19, only 1/3 of countries had the capacities required by the IHR. And while progress had been made in many high-income countries, middle and low-income countries were struggling with funding these functions, which not only impacts their own ability to respond to outbreaks, but puts the entire world at risk. The report was prescient in noting that the great majority of national health systems would be unable to handle a large influx of patients infected with a respiratory pathogen capable of easy transmissibility and high mortality. Now, a second key group of legal obligations under the IHR that are being flouted by states in the present pandemic relate to reporting. The IHR contains a whole host of reporting duties, and most significantly, state parties have a duty to report to WHO what's known as potential public health emergencies of international concern. Some people like to use the acronym FAKE, I like to call them FIX, which occur within their territories by applying a specific algorithm. Now, the lack of surveillance capacity has undoubtedly hindered the ability of countries to identify and report potential threats in a timely manner. But in some cases, such as China's failure to report the initial outbreak of COVID-19, the failure to report was arguably purposeful. Now, in addition to not reporting initial outbreaks of COVID-19, WHO has publicized that states are not meeting a host of other reporting obligations under the IHR. Most and significantly, following a fix, state parties have a duty to continue to communicate with WHO timely and detailed information on the event and health measures such as quarantines that are implemented in response. Reporting on national measures is not only critical for disease containment, but it also enables WHO to monitor if states are complying with their other IHR obligations, including human rights obligations. Now, the third key and final area where states parties are not complying with their IHR commitments is the area of restrictions on trade, travelers, and persons. And this failure has significant human rights implications. Like the old IHR, the revised regulations set forth health measures that states may apply to travelers and goods, such as inspection and vaccination and documentation. Now, discouraging state parties from imposing excessive or additional measures is one of the crucial aspects of the IHR regime. Excessive measures have important economic and human rights implications that undermine implementation of the IHR. And in any outbreak situation, there's a great risk of overreaction and implementation of unjustified excessive measures, which can damage the affected country, and trade, travel, and tourism might well suffer with economic consequences that extend beyond the measures necessary from a public health point of view. And there are a number of previous examples of this, such as the outbreak of cholera in Peru and plague in India. Now, the new IHR incorporated a variety of mechanisms to discourage states from unjustifiably imposing excessive measures. In particular, the regs moved towards a set of restrictions based on key principles, such as the use of least restrictive measures and scientific evidence, as well as key procedures, such as notifications. But states have tended to ignore these provisions and WHO temporary recommendations. For example, WHO temporary recommendations in the context of COVID-19 have discouraged restrictions on trade and travel, and these recommendations have been widely ignored. Despite their recommendations, at least 93% of the global community now lives in countries with coronavirus-related travel restrictions. And while it's been observed that temporary travel restrictions may delay the movement of pathogens, evidence shows that they don't prevent the spread of disease, but rather prevent the movement of aid and experts, create excessive risk for people rushing borders, and disrupt national economies. Now, another emerging concern in this context is that state control measures in response to COVID-19 have significant human rights impacts in violation of both the international health regulations and international human rights law. You know, it's important to note that international human rights law in the Covenant on Civil and Political Rights recognizes that in the context of serious public health threats threatening the life of a nation, restrictions on rights can be justified, subject to a number of conditions. And this principle is also reflected in the IHR. So consequently, around the world, states have implemented a variety of classic public health measures, such as isolation and quarantine, school closures, business closures, that restrict human rights, but are recognized as consistent with international human rights law. However, there are a number of human rights concerns raised by some state action that are not being reported as required and assessed through the IHR process, including restrictions on freedom of expression, privacy, and movement. Notably, all of these restrictions not only violate human rights, but also undermine public health potentially, since restricting communication and overly broad measures restricting movement and privacy undermines trust in government. Other types of national measures are raising additional human rights concern. Of particular importance, which I'm sure you've all read significantly about, are concerns about discrimination, including bias, racism, and xenophobia against persons of Asian descent, and also about state failure to protect persons, older persons, and persons in institutions, including prisons, jails, and immigration detention centers, as well as residential facilities for older people and persons with disabilities. Critics also contend that some governments are using the public health crisis to seize power in a way that has little to do with the protection of public health. Now, all of these new laws broaden national authority and limit civil and political rights in a way that could shape politics for decades after the virus ends. And notably, few of these deliberate restrictions undertaken by governments have been reported to the IHR as required, showing further the increasing irrelevancy and marginalization of WHO and the IHR in the context of COVID-19. So let's move on to our last issue, to the WHO global leadership role that's envisioned by the new regulations and how it's played out in the context of COVID-19. So in the new IHR scheme, WHO is designed to play this global leadership role in surveillance, information exchange, risk assessment, and response aimed at ensuring a proportional public health response to avoid unnecessary interference with trade and travel. And most significantly, the most significant action under the IHR is the declaration by the Director General of WHO upon the advice of an emergency committee of a FIC, or the Public Health Emergency of International Concern. Now, consequent to the declaration of a FIC, WHO may adopt temporary recommendations to guide states and urgent measures to contain the outbreak domestically and control international spread. WHO is also charged in a number of ways to provide direct support to states. Now, it's been widely, I think, agreed that WHO's performance in this key leadership role in the early stages of the pandemic has been weak at best. WHO has been widely criticized by commentators for, among other things, mismanagement of the pandemic, failing to identify a FIC in a timely manner, and being too deferential to China. Now, all of this was brought to fore when President Trump, who had praised the organization early in the pandemic, changed his tune in mid-April and vowed to defund WHO. Now, although the US decision to defund the Global Health Agency in the middle of a pandemic has been widely condemned, it's important to know that President Trump is not alone in criticizing WHO. I would argue that WHO's failure of leadership to provide leadership in this pandemic reflects and reinforces our core understanding of the challenges of sovereignty and the limited authority of international organizations in a world of independent states. When the new IHR were adopted, scholars Larry Gostin and David Fidler described the IHR as a triumph of international cooperation over state sovereignty. And I think this is absolutely mistaken. Although the IHR is binding, states purposefully circumscribe the authority of WHO in disease outbreaks under the instrument. WHO has no independent authority to investigate outbreaks. WHO had no authority to go into China to see what was going on. It's also highly limited in utilizing information from third parties, and the instrument does not include any compliance machinery to encourage state parties to meet their commitments. In the end, WHO must rely on voluntary state cooperation to promote implementation. So overall, this presentation is trying to identify some of the ways in which global coordination on infectious diseases has thus far failed and the implication it has for us as nations and the global community. And I think the global implications were best caught by Dr. David Ho in this poorly shot graphic that I pulled off my TV set. As he pointed out, with global leadership encouraging simultaneous and effective responses among nation states, this pandemic would still be a crisis, but its peak and duration would be shorter. That's the image on the right. But what's happening is the image on the left. Each nation is essentially doing its own thing, with some states like Sweden still not implementing any measures at all, and others lifting measures, perhaps us, too early. So imagine that sort of sequential graph spread out over 200 countries. The consequence of a lack of global coordination is that this pandemic will last longer, and its effects will be deeper for all of us, especially the poorest and most marginalized. Now, no one theory to what has happened to international cooperation under the IHR and its implications for the future can be fully explanatory. I think early responses to COVID-19 remind us that sovereignty isn't dead. Despite globalization, states are still the primary actors in international relations. Realists have argued that coronavirus, although the realist perspective of coronavirus helps explain why states have acted in their perceived self-interest and marginalized the WHO. Realists remind us that international cooperation is inherently fragile, even when it's obviously needed. And some argue that this pandemic gives us another reason to limit globalization. But I think that from another perspective, the COVID-19 crisis is not an end to globalization, but just another chapter in the story. You know, the anti-globalization national populism, which has dominated politics in a number of states for some years, has undermined the financial and political capacity of international organizations such as WHO and the willingness of countries to work cooperatively. This pandemic could bring about the next wave, including strengthening international law and institutions to fight future pandemics. I believe that a core part of this reform will include reforming the IHR and revising it, including strengthening its implementation mechanisms. And I've also recently proposed in an upcoming Insight for the American Society of International Law that the next wave should also potentially include an organizational governance reform involving the development of a joint UN program on infectious diseases. So in conclusion, the immediate lesson from COVID-19 does not, I think, support national isolationism. COVID-19 evidences the concrete link between infectious disease control and global health security. It's shown us that simple divisions between domestic and global health do not work. That's a lesson we should have learned long ago. It vividly illustrates the challenge of battling infectious diseases in an increasingly interconnected world. So I think the ultimate lesson of this pandemic is that nations need to cooperate more and not less. Thank you for your patience.
Thank you. Let's see, if people have questions, and we've got about 10 minutes for questions, why don't you raise your hands? And I've got, while people are doing that, I have one quick question. From a purely legal standpoint, as a matter of international law, the IHR, it's not a treaty, it's not a multilateral treaty, but what is its legal status? Like, does it derive from the WHO treaty? Is that where it gets what you would characterize as you know, international law? Or is it just some kind of a norm or kind of thing?
Well, I think we want to be very clear that the IHR is binding international law. Now, some people argue that it is formally a treaty. I think under the Vienna Convention of the Law of Treaties, that's an inaccurate description because it doesn't rely upon straight consent and ratification. I would argue that it derives its authority from the WHO Constitution and the consent that states have given to the Constitution. So even though it's not formally a treaty, it is binding in the way that a treaty is, and we use the rules of international law, including the Vienna Convention, in considering how to interpret and apply it.
Okay, thanks.
Professor Taylor, this is Professor Igrodsky.
Yeah.
Thank you. I did officially raise my hand because we are a lot of people on this call. Thank you so much on behalf of all of our sections. So even though technically this is binding international law, does it still make sense to keep referring to it and talking about it as such, to the extent that there is minimal to no compliance and minimal to no enforcement? Would it make a difference, or would we be better off as a matter of buying if we just talked about it as soft law, right? As a form of aspirational, non-binding norms. And separately, like most traditional international law, it addresses governments. It doesn't bring to the fold civil society organizations or industry, private sector, with the exception of, I think, the Gates Foundation, which is one of the biggest payees or donors into the WHO, if we go through another round of revisiting the IHR, should we be thinking about bringing in the private sector, civil society organizations, like we're doing with business and human rights, for example, in a non-binding way?
Well, that's a great bunch of questions. Let me try to answer. First of all, I personally do not like the term soft law. I think it's a lot like being a little bit pregnant. You know, either it's law or it's not law. The fact that the IHR does not have an enforcement mechanism is not unique. Oh, you like that little joke. Is that, you know, most international instruments do not contain enforcement mechanisms. What they do contain are compliance mechanisms. And that's one of the ways that the IHR really needs to be reformed. I have to say, the old international health regulations, the 1969 ones, I wrote about them in the early 2000s, and I said that, and this, I think the point you're making, is that they were obsolete as a matter of international law and should not be considered international law. I'm not sure if we're there yet with the revised IHR, because it is a very dense instrument, and in fact, parts of it are being complied with even during this pandemic. In fact, a colleague of mine at the U.S. State Department told me, she's in the Oceans Division, that she and her colleagues were referring to the IHR when trying to argue with the Canadians about letting our ships pass through Canadian waters during this pandemic. I think your point about it's to the limitations of binding international law in general, failure to include industry and non-state actors and you know, organizations such as the Gates Foundation is very well taken. And it's one of the reasons that I argue that we need to develop a joint United Nations program on infectious diseases. And my idea is modeled a little bit on the joint UN program on AIDS, which does include non-state actors, including 5 spots for NGOs. I agree with you. We need to rethink and revise the organizational structure for this and the instrument itself.
See, we've got 2 questions. One first from Tyler and then Maya, and then we'll probably run out of time. Tyler?
I just wanted to ask you, you spoke earlier about how the WHO has been widely criticized for essentially adopting a very a line which is a line throughout this crisis, which has been very friendly towards the government of the People's Republic of China and their sort of official line on diseases. And this is culminated in our administration defunding the American commitment to the WHO. So I guess there's a lot of work that's been put into building up the WHO over the years. As the WHO has certainly done a lot of good work on things, and I don't personally think the correct answer to the WHO's issues with China is throwing the organization wholesale into a wood chipper. So I mean, as far as, and I apologize if you may have answered this somewhat already as far as a UN organization, but I mean, to restore confidence in the WHO's ability to deal with diseases in a correct and impartial manner, even when national governments may not necessarily want that. I guess what kind of reform would you like to see, and do you think would be effective?
Well, I mean, that's the $1 million question. I do want to say that I was around at WHO in 2002, 2003 when the SARS pandemic broke, and you know, WHO acted the exact same way with China at that point, and China was it was also slow to report. Though technically it wasn't required to report. That's before the revision of the IHR. I think ultimately that the problem of infectious disease control, these major pandemics, is larger than the organization, because any public health decision is going to be inherently political. Declaring a FIC, is going to and does result in states undertaking quite a number of actions that hurt the economies and peoples of affected countries. That's part of the reason why I think that this should be a joint UN program. WHO needs more political cover. And what it doesn't do well, I mean, actually, I hope some of you will take my class next year if it's offered, the Globalization of Infectious Diseases, is that WHO doesn't have a strong history in working in international law and international sort of political relations. It actually has only been the framework for the adoption of one treaty, the Framework Convention on Tobacco Control. But what it does do well is that really strong surveillance and epidemiological and information exchange. And so I think that under a new legal regime, that is the part that WHO really has to focus on. I'm not sure if I completely answered your question, but I also want to say that I think that it absolutely is a mistake to throw WHO into the wood chip in the middle of a pandemic. I mean, even now, the organization is leading global efforts to develop vaccines. So we need to keep that in mind.
Maya, last question.
Hey, this one should be fairly quick. You were saying that most international instruments don't contain enforcement mechanisms, but do contain compliance mechanisms. And to be honest, I'm not sure I fully understand the difference between the two. And so I would love it if you could clarify that.
But this is like my own view, and your professors, may disagree with me, but enforcement is very rare. My view is enforcement is very rare in the international system and really arises in the context of peace and security under Chapter 7 of the United Nations. So when I teach compliance in an international law organization class, I like to think of it as a continuum of mechanisms of states that are not rough on sovereign nerves to those that are. And so one of the things we have in compliance is technical advice, financial advice, assistance, effective and cogent reporting and supervisory mechanisms. And then we could move more towards sort of the stronger end, issues such as inspections, issues such as penalties, right, which and responses, which is what you see, for example, in international trade law, right? Countermeasures. And then, but enforcement is rare, is the actual enforcement is rare. And so I think the term is misleading. I think that we can design international instruments, including the IHR, to make them more effective instruments of international cooperation by including those mechanisms that encourage states to comply with their international commitments.
Great. Thank you very much, everybody.
My pleasure.
Allyn, thanks very much. Really appreciate it. And again, folks in my section should hang on, and then in the other sections, then you can log off and log back on. Thank you.
Thank you. My pleasure. Bye.
Appreciate it.